Esteemed ladies and gentlemen, my topic is not strictly the Russian investigation, but rather the current status of Katyn case in Russia. But first of all, I would like to offer my thanks to the organizers for invitation to this conference and for giving me the honor of speaking to you as a representative of Russian Memorial Society. And I am sorry very much for my poor English. The Memorial Society, in addition to its activity in defending human rights in Russia today, also conducts the study of the history of political repression in the Soviet Union, documenting the fate of repressed people and assisting their moral and legal rehabilitation. And another statutory task of the Memorial Society is to promote access to sources of information about the crimes of totalitarian regime. By education, I am not a historian and certainly not a lawyer, but I work at the research center of Memorial, and I am engaged in last year. I am engaged in studies of the history of Soviet political repression against Poles and Polish citizens. In addition, in last year, I have to deal with some certain legal issues as one of the representatives of our society in proceedings of some aspects of the Katyn case before the Russian courts. Already several years, Memorial Society is seeking the realization of measures at the state level, without which a legal resolving of Katyn case in Russia is impossible, in our opinion. These measures, this is firstly the adoption of the adequate legal qualification of the Katyn crime, corresponding to its essence as the act of Soviet state terrorism. Second, the procedural establishment of all perpetrators, starting with those who decided on the massacre of thousands of Polish citizens and finishing with all the ordinary performers of extrajudicial executions. None of them are no longer alive, so they cannot be put before the court, but their names must be disclosed. This is our opinion. Third, the recognition by name of all prisoners of war and regular prisoners who were shot in the Katyn massacre as the victims of political repression in accordance with existing current Russian law on the rehabilitation of victims of political repression. And fourth, the declassification of all materials of the Katyn massacre investigation conducted by the Russian main military prosecutor's office from 1990 to 2004. Before presenting the current state of affairs in this regard, I would like to remind you how changed the official position of the Soviet Union and Russia for Katyn case. Since the autumn of 1941 to March 1943, Soviet authorities claimed that they know nothing about the fate of Polish officers captured by the Soviet captivity in September 1939. After the announcement by the Germans in April 1943 about the discovered graves of shot Polish officers in the Katyn forest, Soviet authorities until April 1990 claimed that the execution was carried out by the Nazis, who allegedly captured in the summer of 1941 three Soviet camps for prisoners of war near Smolensk, in which Polish officers were kept. The final report of Special Burdenko Commission, designated in the very beginning of 1944 to investigate the shooting of Polish officers, this report was intended to provide the visibility of legal basis for lying Soviet official version. The evidence which the Burdenko Commission had relied on subsequently proved to be fabricated. The evidence and the testimony, eyewitness testimony. Only in April 1990, under President Mikhail Gorbachev, the Soviet Union has acknowledged guilty Beria, Merkulov, and their henchmen of committing a massacre of Polish prisoners of war. In the official statement of governmental TASS agency, their execution was described as one of the serious crimes of Stalinism. In the autumn of 1990, the Soviet main military prosecutor's office began to investigate Katyn massacre. After the Soviet Union disintegration, the investigation of the criminal Katyn case was continued by the Russian main military prosecutor's office. In October 1992, Russian President Boris Yeltsin directed to make public the document showing that the extrajudicial execution of Polish citizens had been carried out on the orders of the Soviet leadership, Stalin personally, and 5 other members of the Politburo of the Central Committee of the Communist Party. However, this political position did not find then its legal expression. Official legal position has been formulated only on September 21st in 2004, when the main military prosecutor's office dismissed the criminal Katyn case for the death of the guilty, and simultaneously classified the investigation materials as secret and top secret, including the very decision, the very resolution to dismiss the case. This was announced publicly only after 6 months, in March 2005. Referring to the secrecy established by itself, the main military prosecutor's office refused to announce the perpetrators by name, saying only that they were a few leading officials of the NKVD, Soviet secret police. Their actions being qualified under paragraph B of Article 193-17 of the Penal Code, Russian Penal Code, valid in 1940, namely as the excess of authority that had adverse consequences in the presence of specially aggravating circumstances. Thus, the main perpetrators, Stalin and Politburo members, were excluded from the circle of persons responsible for the Katyn massacre. And the extermination of thousands of Polish citizens were qualified as an ordinary crime that is subject to a 10-year statute of limitations. From the persons responsible for the shooting were also excluded all performance of operation to shoot 22,000 Polish prisoners of war and arrested persons, except a few, the leaders of the NKVD. Only one explanation of this may be possible. The contemporary Russian main military prosecutor's office does not consider carrying out of a criminal order as a crime. In 2005-2006, the main military prosecutor's office completed its legal position that, in contrary to the requirements of the existing current Russian law on the rehabilitation of victims of political repression, refused to consider the question of recognition of each individual shot prisoner of war as a victim of political repression. Main military prosecutor's office refuses to recognize not only a political motive, political reason, but even the very fact of execution of each individual prisoner of war, referring that the individual documents about the shooting were not preserved. It means, while not denying the fact of mass executions of Polish prisoners of war, the main military prosecutor's office seeks to save them as a multitude of nameless, anonymous victims. Thus, the official legal position in the short term is this: the investigation terminated, the materials being classified, the Katyn massacre is qualified as ordinary crime that occurred a long time barred. Guilty are only a few leaders of NKVD, but not Stalin with the other members of Soviet leadership. And finally, the victims of the shooting are not subject to rehabilitation. After March 2005, attempts were made to influence the formal legal position. Applications for rehabilitation in accordance with the law on the rehabilitation of victims of political repression of a number of individual shot Polish prisoners of war were submitted to the main military prosecutor's office. Applications for rehabilitation of 16 of them were submitted in 2006 by the Memorial Society as the first step to roll by name rehabilitation of all those executed by the decision of the Politburo of the Communist Party taken on March the 5th, 1940. Applications for rehabilitation of 10 more victims of execution were filed by their relatives, including the son of one of the shot prisoners of war who lives in the USA. The relatives were represented in Russia by Moscow lawyers Anna Stavitska and Roman Karpinsky, acting independently of the Memorial Society. Refusals of the main military prosecutor's office to execute the Russian law on the rehabilitation in relation to individual shot Polish prisoners of war were appealed by the Memorial Society and independently by other claimants in the Russian courts of first, second in Russian cassation and the supervisory instances, the Khamovnichesky District Court of Moscow, the Moscow Military District Court, the Moscow City Court, the Presidium of the Moscow City Court, the Supreme Court of the Russian Federation. Family members of executed prisoners of war, in addition to the rehabilitation of their relatives, demanded to cancel the decision of the main military prosecutor's office to dismiss the criminal Katyn case, to reopen the investigation, to acknowledge the status of victims for them in accordance with the Russian Criminal Procedure Code, and to give them the opportunity to get acquainted with case materials. All of the above named courts on behalf of Russian Federation denied to meet the complaints, thus confirming the legal position of the main military prosecutor's office as the official position of Russia. As a result, the Memorial Society and independently other applicants were forced to turn to the European Court of Human Rights in Strasbourg to complain about a violation by Russia of the European Convention on Human Rights and Fundamental Freedoms. Currently, the European Court considers as a priority the claim of 10 families of executed Polish officers. The complaint of the Memorial Society is awaiting their turn to examine. Next, in 2006 and 2008, the Memorial submitted to the main military prosecutor's office the request to declassify the key document of the Katyn case investigation, namely the resolution on its termination. According to the Russian Criminal Procedure Code, the resolution to dismiss a criminal case must contain in short form all the results of the investigation. Memorial consider the classification of this important document as the first step to open all the closed materials of the Katyn case investigation. Memorial refers to Article 7 of the Russian law on state secrets, according to which classification of information about violation of human rights and freedoms of man and citizen, as well as information about violations of law by governmental authorities and their officials, is prohibited. The refusal of the main military prosecutor's office to perform the procedure assigned by law on state secrets was appealed by the Memorial in Khamovnichesky District Court of Moscow. Unfortunately, this court of first instance and then the Moscow City Court, in which the Memorial filed a cassation appeal, found no violation in the actions of the main military prosecutor's office. In 2009, the Memorial Society turned to Russia's highest state authority in the area of secrecy, namely the Interdepartmental Commission for the Protection of State Secrets, the activity of which is supervised by the President of Russian Federation. Memorial demanded to cancel the decision on classifying the resolution to dismiss the criminal Katyn case. The refusal of the Interdepartmental Commission was appealed by Memorial to Moscow City Court, which in November last year, 2010, ruled that the actions of the main military prosecutor's office and the Interdepartmental Commission to classify the resolution of termination were legitimate. Despite the flagrant violations, in our opinion flagrant, of the Civil Procedure Code committed by the Moscow City Court, the Supreme Court of the Russian Federation on 26 January this year, a week ago, upheld the decision of the Court of First Instance. Thus, now the Memorial Society is faced with the need to send a supervisory complaint to the Presidium of the Supreme Court of the Russian Federation concerning the illegality of the classification of key material of Katyn case, as well as the next complaint to the European Court of Human Rights. Here we must note the two particular features of the Memorial Society's application to the courts. First, although the Memorial Society does not reject the possibility of recourse to international justice, but we would really like to achieve the solution of Katyn case in the Russian courts, because the Memorial consider the Katyn case primarily as an internal problem of Russia itself, and even then as the problem of Russian-Polish relations. Secondly, appeals on Katyn case filed by Memorial in the Russian courts and the European Court of Human Rights formally are the complaints of violation of the right of the Memorial Society itself to carry out its statutory activities and to its right for a fair trial. This is the difference from the court cases brought by relatives of shot prisoners of war, who complain of a violation by Russia their own rights as victims. Meanwhile, last year in 2010, however, aroused some new situation. After 70 years of silence, the Russian authorities at last articulated its political position concerning the Katyn massacre. The start was even before the tragic crash of the Polish presidential plane near Smolensk. In spring 2010, firstly Prime Minister Putin and then more definitely President Medvedev have publicly voiced his opinion about Stalin's culpability in the massacre of Polish citizens. In the statement of the Russian Parliament, State Duma of the Russian Federation, taken on November the 26th last year, it was for the first time made public the official recognition by Russia of the personal responsibility of Stalin and his associates as the main perpetrators of Katyn massacre. In 2010, copies of 137 of the 147 volumes of unclassified materials of Russian investigation of Katyn criminal case were handed over to Poland, but none of the other 36 secret or top secret volumes has not yet been declassified and handed over. But the press office of President Medvedev has sent a comment about the recent decision of the Supreme Court of the Russian Federation. This comment is to ensure that the declassification of Katyn case materials is going on, and after finishing, the copies will be transferred to the Polish side. Formally, there is no contradiction. The recognition of declassification being legal in the past does not preclude the declassification in the present time. So despite the recent decision of the Russian Supreme Court, some slip of Russia's official position may occur, at least on the declassification. In general, the political declaration on Katyn case are welcome, but the contradiction between the statements of Russian authorities and the legal position of the main military prosecutor's office, unchanged since 2004, has now become more striking. While the legal position of the Russian state will not be aligned with political declaration, Katyn case in Russia cannot be considered as closed. Thank you for your attention.
Ladies and gentlemen, my presentation is about the Katyn investigation by the authorities of the Republic of Poland. Of course, such an investigation was impossible prior to 1991 for political reasons. In July of 1991, the auxiliary Polish investigation, which served as an adjunct to the Soviet National Military Prosecutors' investigation, was initiated. Pursuant to a decision by the then Justice Minister Aleksander Będkowski, Stefan Śnieżko was appointed coordinator. Notwithstanding the Soviet investigation, which was underway, and in light of the decision dated September 2, 1993, by Justice Minister Piotrowski, steps were undertaken to initiate an independent Polish investigation into the Katyn massacre. A number of individuals from the Warsaw Prosecutor's Office were designated to work in this unit, which was in receipt of materials previously in the possession of Mr. Śnieżko, and they were charged with the responsibility of organizing and conducting the Polish Katyn investigation. The unit was headed by the prosecutor Alexander Herzog. This specific unit was later dissolved, and the materials in its possession were transferred to the Instytut Pamięci Narodowej or Institute of National Remembrance in January 2000. In making the decision to initiate the Polish investigation, it was agreed that by sanctioning the Katyn massacre, USSR government officials involved had committed an illegal act which included a deliberate operation to execute thousands of Polish prisoners of war and civilians, which act, as understood by international law and convention, was a war crime and crime against humanity. There exist multiple goals in the above referenced investigation, which include a unified and comprehensive documented explanation of the circumstances in this matter, including, among other issues, a detailed listing of the names of all the Polish citizens who were victims of the Katyn massacre, determination of heretofore unknown massacre and burial sites of these victims, ascertaining the names of all those involved in making the decision dated March 5, 1940, as well as the names of those involved in execution, the decision, and determining the scope of a responsibility, and finally bringing the still living perpetrators to justice insofar as it is possible. Another goal is the formation of a complete list of those who are defined as injured as a result of the loss of their family members as based on Polish law. Investigatory process case number S34/04K. An investigation was conducted by the Interdepartmental Investigative Unit, which was dissolved by order of the Director of the Chief Commission of the Prosecution of Crimes against the Polish Nation, a division of the IPN, in 2008. It was replaced by a 3-member investigative unit consisting of prosecutors from the Chief Commission working on case number S38/04ZK. The work of this specific unit is aided by the remaining 10 regional commissions, which aid the Chief Commission by conducting interviews of witnessing parties in their respective regions. Documentary efforts of the investigative process concentrate primarily on interviewing witnesses both in Poland and abroad, as well as locating archival material which refers to the Katyn massacre. As a result, a total of 2,589 witnesses have been questioned, with the greater majority being immediate family members of the victims. Among those recently reviewed, it is particularly relevant to mention the testimony of Henry T., who related that he was transported as a forced laborer to Smolensk in February 1942, and that in the spring of 1943 he was an eyewitness to the exhumation conducted in the Katyn forest. This testimony, as well as other items referred to in this presentation, has proved that despite the passage of 70 years, new materials and evidence continue to be discovered. International cooperation. Cooperation with the ministers of justice of Russia, Ukraine, and Belarus is of great importance in the investigators' work concerning the Katyn massacre. Cooperative endeavors with the Russian Federation. Because of its great import for the prosecution, the documentary evidence collected in the investigation recorded as case number 159 of the National Military Prosecutor of the Russian Federation with respect to the Katyn massacre, the Regional Commission of the Chief Commission in Warsaw, through the good offices of the Polish Ministry of Justice, submitted a request that the Prosecutor General's Office of the Russian Federation extend all possible legal aid and assistance. This included a request for verified photocopies or copies of the completed prosecutorial documentation found under number 159 in the records of the National Military Prosecutor of the Russian Federation, and additionally for a verified photocopy or copy of the decision to suspend said investigation and the transfer of all aforementioned documents to the All Russian Workers' Party dated March 5, 1940, concerning the murder of the Poles. The Russian side did not allow for photocopying of the documents that had been reviewed, nor was the entirety of the case material made possible, with this decision being based on the statement that a portion of them were designed as secret. This designation was also applied to the decision dated September 21, 2004, suspending investigation number 159, and this designation precluded, despite the repeated request of the IPN prosecutors, its review. On September 30, 2009, the Regional Commission in Warsaw forwarded a second request through the Ministry of Justice to the prosecutorial offices of the Russian Federation, in which it requested once again for legal assistance on criminal case number S38/04ZK by making the entirety of the National Military Prosecutor's case files referencing case number 159, as well as the decision concerning the suspension of the case, the verified photocopies of the entirety of the investigation, as well as the decisions of the suspension of the investigation and concurrence for the transfer of all documentation concerning this case available for review by the Polish investigators. In May of 2010, the Russian Federation transferred the 67 volumes of materials which had been previously reviewed, while in September an additional 20 volumes and in December a final 50 volumes were received. In total, 137 volumes of materials concerning the Polish prosecutors was transferred. The response of the Prosecutors General of the Russian Federation dated June 28, 2005, which was transmitted through the offices of the Ministry of Justice of the Republic of Poland, was received by the IPN on July 28, 2005. The reply advised that the Russian side would make available 67 volumes of case material referencing case number 159 of the Military Prosecutor General's Office of the Russian Federation. This correspondence did not clarify why all the material would not be made available, nor was any reference made to the possibility of the Polish side receiving a copy of the Civilian Prosecutors General's investigatory materials and a copy of the determination which terminated investigation number 159. At the invitation of Military Prosecutors General Office of the Russian Federation, and during the period of October 9, 2005, 3 prosecutors representing the IPN Regional Commission in Warsaw, as well as the chief specialist of the Chief Commission, visited Moscow. During the course of the visit, they were able to acquaint themselves with the materials contained in the 67 volumes referencing case 159 that had been made available and made appropriate documentary notations. Nonetheless, this work did not lead to the acquisition of any essential information about the Katyn massacre and not increase the available information about the subject matter. The documents made available did not include the criminal edict of the Politburo to the Central Committee of the investigation of case number 159, while another 36 volumes considered to be top secret have not been transferred. Cooperative endeavors with the Republic of Ukraine. On August 18, 2005, the Regional Commission in Warsaw also requested that the Prosecutor General of the Ukrainian Republic assist with legal efforts on the ongoing investigation. Specifically, reference was made to the materials gathered by the Ukrainian prosecutors in 5 cases, but particularly in case number 50-0092 Bukovnia, concerning the discovery of mass graves in the Bukovnia forest in Kiev Oblast, which the Polish prosecutors wished to review. The Prosecutor General of the Ukrainian Republic extended an invitation to the 3 IPN prosecutors as well as the chief specialist of the Chief Commission, who were able to work in the Kiev office during the period of November 5, 2006. This visit enabled the group to familiarize themselves with 22 volumes of procedural documentation from the Ukrainian Military Prosecutor's Office in the Kiev region, number 50-0092, in the case of the mass graves in the Dnieper forest of the Bukovnia near Kiev, the investigation of which was suspended by decree of June 25, 2001. They were also able to review the contents of 35 volumes of case material of the execution of Polish officers and Polish civilians in 1940-41 by the NKVD of the USSR, gathered by the Ukrainian Military Prosecutor's Office in the northern region. This investigation is not concluded. As advised by the Ukrainian Military Prosecutor's Office in the central region, it is conducting preliminary procedures in this case. In August 2007, through the good offices of the Embassy of the Republic of Poland in Kiev, the Regional Commission in Warsaw received a selection of materials gathered in the 22 volumes, which each volume consisting of several hundred pages. During the course of the proceedings, a request was sent in April 2007 to the Prosecutors General of the Ukrainian Republic regarding legal assistance by sending a verified photocopy of what is referred to the Ukrainian Katyn list. That is a list of 3,435 Polish citizens who had been detained in prisons in what is referred to the Western Ukraine and who had been executed as a result of the order dated March 5, 1941. The subject list was submitted for use in the investigatory process, reference as S3804ZK, in August 2007. Cooperative endeavors with the Republic of Belarus. In September 20, 2002, the Minister of Justice of the Republic of Poland submitted a request to the Minister of Justice of the Belarusian Republic in which they asked for a determination as to whether the prosecutor of the Belarusian Republic had conducted an investigation into the matter of the mass graves in Kuropaty near Minsk, and for a copy of the evidence thus collected. Based on the reply received in 2003 from the Belarusian Republic, it appears that during the course of conducting the case in the matter of disclosing the identities of those individuals buried in the Kuropaty forest preserve in the Minsk region, the nationality and citizenship of the exhumed skeletal remains was not determined. Thus, the Belarusian side did not release any photocopies of the materials involved in this case. In response to the Russian decision to terminate the Katyn investigation, the Polish Parliament on March 22, 2005, adopted a resolution expressing regret that the Katyn crime became politicized in order to downplay its significance and to evade responsibility for the crime. The resolution stated, "We expect from the Russian nation and from the Russian Federation the clear admission of the genocidal character of the murder of Polish prisoners of war as defined by the Nuremberg trials. We also expect that all circumstances in this crime will be revealed, in particular the location of the burial of a large number of murdered prisoners whose graves have still been impossible to locate. We expressed our disappointment that the Katyn investigation has been terminated by the prosecutorial authority of the Russian Federation. We expect that all the documents from the Katyn investigation will be released. The Sejm of the Republic of Poland expresses its support of the Institute of National Remembrance to conduct the investigation into the Katyn crime and considers it necessary to continue activities so undertaken. Cooperative endeavors with other nations. A request for legal assistance was also issued to the Ministry of Justice of the Republic of Germany. As a result, the Regional Commission in Warsaw conducted research in the subject matter in designated German archives. Photocopies of documents were received from the Prosecutor General in Koblenz, Rhine Region Palatinate, which originated in the political archives of the Foreign Ministry in Berlin and the Federal Archive in Koblenz. Additionally, the German Foreign Office wrote suggesting that the need for a personal review by the IPN prosecutors of the archival material contained in the political archives of the Ministry of Foreign Affairs in Berlin, which review was conducted on July 1922, 2005. These documents were transferred as microfiche copies by the Germans to the Regional Commission in Warsaw. With respect to conflicting information as to the contents of the Soviet documentation of Smolensk, which was captured by the Germans in the summer of 1941 and which was transferred by them to the Reich and then was seized by the Americans, a decision was made concerning the necessity of conducting research on the issue of the Katyn massacre in these materials. Despite the passage of decades, the investigation continuously unearths new material about documents in foreign archives. In November of 2007, detailed information was received about the research results of the queries conducted in London by IPN archivists concerning Katyn in the archives of the Polish Institute and General Sikorski Museum and the Polish Underground Movement Study Trust, also in London, and the Polish Library. What was clear was that there was a large amount of material which might have significance in the investigation of case number S3804ZK. The selective archives of the Polish Institute and the General Sikorski Museum consisted of 321 items and over 1,000 pages, mostly in the Polish language. An important source of information for the investigation will, with certainty, will be the expensive documentation accumulated by the Select Committee to conduct the investigation of the facts, evidence, and circumstances of the Katyn Forest Massacre of the 82nd Congress. Steps have been undertaken through the offices of the Embassy of the Republic of Poland in the United States to determine the extent of the documentation and the possibility of reviewing it by the National Archives in the United States. In May of 2009, the Polish Ministry of Justice, acting on behalf of the IPN, submitted a request for legal assistance in the subject matter to the Authority General of the Republic of Poland. There are some other institutions and persons cooperating in this investigation, including Mrs. Krystyna Piórkowska, who is present in this hall, and she was able to locate several important documents concerning, for example, German interpreter Georg von Johnson, who was in Katyn, and also South African Colonel Frank Stevenson, who was in Katyn in 1943. Thank you for your attention.
I guess we have a couple minutes for questions, so please, we have a microphone here. Any questions? Yes, please.
Point
How-
of
wait,
correction,
can you wait?
George Earl was not sent to investigate the Katyn massacre. George Earl was a minister to Bulgaria and Austria and a special emissary to the Balkans. In that role, he was in contact with individuals from the Balkans, and in his testimony, he clearly states that he received materials from 2 Bulgarians and 1 Romanian who had had personal contact on the issue of Katyn. And he states that in their reports, which were given to him in the Istanbul, they declared their presence in Katyn during the investigation. This would lead to the understanding that these 3 individuals were Dr. Berkle, Dr. Markov, who later testified on behalf of the Soviets, and Dr. Miloslavic, all members of the International Commission. Earl was never sent to investigate, and he was functioning in a completely different role. And it is clear that Earl, in his correspondence with Washington, had to write to Roosevelt's daughter because of Harry Hopkins' influence. The second thing I would state is that it was not Bissell who attempted to justify himself on the basis of papers that he submitted during the testimony in front of the Madden Commission. Rather, Bissell was handed documentation that had been received from the State Department, and on that correspondence, the cover letters to the Van Vliet memo and the cover memo of August 45 to the Gilder memo, he clearly found, the Madden Commission representatives found notations which were cipher numbers entered by the State Department when they received a document. And there were cross-references to the Van Vliet report there. And this is a heretical position on my part. However, it is not my belief that this will destroy the report.
Okay, thank you very much for your comment. Please use the microphone. We need to use the microphone. Okay. Yes, please.
For Dr. Guryanov, I'm Henry Sokolowski with the Kresy Siberia and Polish Combatants Associations in Toronto. I read in the newspaper quite a few months ago that the Russian authorities have been harassing the Memorial Society. There was a report of some computers being confiscated or files taken away. If that report is true, is the harassment continuing, and how are you dealing with it?
Moment.
You've always been harassed.
Ну, я не слышал об оскорблениях.
Well, he really doesn't know anything about harassment.
Ну, вот за последние 4 года у нас состоялось более 40 судебных заседаний по нашим обращениям в связи с Катынским делом.
For the recent 4 years, there were more than 40,
Более 40.
more than 40 hearings concerned with the Katyn case, and
Нам не удалось выиграть ни одного нашего дела.
we didn't succeed. We didn't win on any one of those cases.
Но можно ли это назвать оскорблением со стороны российского правительства? Ну, я сомневаюсь.
I don't think that I can call it harassment from the Russian authorities. It cannot be called harassment.
Okay. Any more questions? Yes, please. Yes, sure. Professor
I
Katyn.
think just in response though, you were talking about a different part of Memorial's has quite a few responsibilities, and the St. Petersburg branch in I think it was December of 2009 had its offices raided by the local the local authority, the FSB, you know, the state security, and they later did, through the courts, regain those files, but the harassment was evident. And similarly, the head of Memorial, more recently, as a result of comments made last year in connection with Ramzan Kadyrov, the head of Chechnya, whom he accused of complicity in the murder of a Russian journalist. And most people do think that is the case. But as a result of that, he too has come under harassment. So some parts of Memorial clearly have been harassed, but Alexander's investigation, I think, is what he was addressing.
Any more questions? Yes, please.
Thank you. I'd like to say that I found your comments very enlightening and informative. I've enjoyed this afternoon as well as this morning's presentations. I'm a little bit surprised that none of the speakers has mentioned or addressed the fact that Poland had a 10-year peace treaty, 1934, when Pilsudski was still alive, as well as with Germany, that ran for 10 years from 1934. Secondly, no one has brought up the March 1939 guarantee by Neville Chamberlain's government following Munich, when Joseph Beck and the Polish ambassador to Great Britain met to sign this guarantee that guaranteed Poland's sovereignty and borders unconditionally. That these men, these officers, reserves as well as active officers, were the representatives of a legitimate sovereign government who was at peace with the Soviet Union on September 1st, 1939, as well as beyond. And there's also the interesting question, why did France and Great Britain declare war only on Nazi Germany? Nobody ever declared war on the Soviet Union after the Soviet Union invaded Poland on September 1939 from the east. Thank you very much for a very informative and enlightening program.
And with that, we will conclude our session, third session of this afternoon, and 15-minute break.